Good evening, attorney. Good evening, classmates. My group and I will be reporting on special corporation, and my report will start on Chapter 1, Educational Corporation. Section 105, Educational Corporation shall be governed by special laws and by the general provisions of the Revised Corporation Code of the Philippines. The applicable laws in the special laws are BP 232 as amended by RA 7798, and the general provisions of the Revised Corporation Code of the Philippines are Section 45, Section 78, and Section 95, where Section 45 provides that the SEC shall not accept for filing the bylaws or any amendments of any educational institution unless accompanied by certificate of the appropriate government agency. Such bylaws or amendments are in accordance with the law. And under Section 78, in the case of merger or consolidation of educational institution. And Section 95 also provides that educational institution cannot be organized as closed corporation. The terms of such educational corporations shall have a perpetual terms unless they choose to have a fixed term. Section 106, educational corporation may be organized as stock and non-stock corporation. On stock corporation, number and terms of directors shall be governed by the provision on stock corporation. When an educational corporation is a non-stock corporation, the number of trustees shall not be less than 5 nor more than 15. It is mandatory that the number of trustees shall be in multiples of 5, and the staggering of terms is also mandatory. The phrase "unless otherwise provided" in the articles of incorporation or the bylaws, in which you can find in paragraph 2 of section 106, is not an exception to the required staggered term. It only refers to the option to provide a different percentage of a staggered term. Instead of 5 years, the Article of Incorporation or the bylaws of an educational corporation may provide for a term of 2 years, and any director who continues to serve after such 2 years term is only occupying for the office in a holdover capacity. Article 14, Section 4, Paragraph 2 of the Constitution states that foreigners are not allowed to become members of a board of directors, trustees of educational institution. And under Article 2, Section 17 of the Constitution provides that the state shall give priority to education, science and technology, arts, culture, and sports to foster patriotism and nationalism, accelerate social progress, and promote total human liberation and development. And there are other provisions relating to education that you can find in Article 14 of the Constitution. In Education Act of 1982, under Section 25 provides that any private school proposed to be established must incorporate as either a non-stock corporation or a stock educational corporation. And the requirements for stock corporation is number one, minimum paid up capital, not less than 1 million for elementary education only, not less than 2.5 million for elementary and secondary education, and 5 million for elementary, secondary, tertiary, and postgraduates. Number two, Existing educational institutions organized as stock corporations may retain their original capitalization. Number three, last one is stock educational institutions may be allowed only in capital intensive courses of study, as may be determined by the Department of Education, the Commission on Higher Education, and the Department of Science and Technology, as the case may be. Chapter 2, Religious Corporations. Section 107, religious corporations may be incorporated by one or more persons. Such corporations may be classified into corporation sole and religious societies. Religious corporations shall be governed by Title 13, Chapter 2 of the Revised Corporation Code of the Philippines and by the general provisions on non-stock corporation as applicable. For purpose of administering and managing as trustee the affairs, properties, and temporalities of any religious denomination, sect, or church, a corporation sole may be formed by the chief archbishop, bishop, priest, minister, rabbi, or other presiding elder of such religious denomination, sect, or church. In section 109, the chief archbishop, bishop, priest, minister, rabbi, or presiding elder of any religious denomination, sect, or church must file with the commission the articles of incorporation in order to become a corporation sole. It must comply with the following: letter A, that the applicant must be a chief archbishop, bishop, priest, minister, rabbi, or presiding elder that represents the religious denomination, sect, or church which desires to become a corporation sole. Letter B, that the rules, regulations, and discipline of the religious denomination, sect, or church are consistent with becoming a corporation sole and do not forbid it. Letter C, the chief archbishop, bishop, priest, minister, rabbi, or presiding elder is charged with the administration of the temporalities and management of the affairs, estate, and properties of the religious denomination, sect, or church within the territorial jurisdiction as expressly described in the Articles of Incorporation. Letter D, when there is a vacancy occurring in the office of Chief Archbishop, Bishop, Priest, Minister, Rabbi, or Presiding Elder, is required to be filed according to the rules, regulation, or discipline of the religious denomination, sect, or church. And lastly, letter A, na the place where the principal office of the corporation sole must be established and located within the territory of the Philippines. And in the Articles of Incorporation, it may include any other provision not contrary to law for the regulation of the affairs of the corporation. Section 110, in submission of the Articles of Incorporation, it must be verified first by affidavit or affirmation of the Chief Archbishop, Bishop, Priest, Minister, Rabbi, or Presiding Elder, as the case may be, and accompanied by a copy of the commission, then certificate of election or letter of appointment of such Chief Archbishop, Bishop, Priest, Minister, Rabbi, or Presiding Elder, duly certified to be corrected by any notary public. After filing with the Commission of the Articles of Incorporation and verified by affidavit or affirmation and then accompanied by the documents The chief archbishop, bishop, priest, minister, rabbi, or presiding elder shall become a corporation sole, and all temporalities, estate, and properties of the religious denomination, sect, or church shall be administered or managed by them and shall be personally held in trust as a corporation sole for the use, purpose, exclusive benefit, and on behalf of the religious denomination, sect, or church, including hospitals, schools, colleges, orphan asylums, personages, and cemeteries. This religious group does not necessarily need to be registered with the sect if they don't want to acquire juridical personality separate and distinct from its member. The revised Corporation Code of the Philippines does not require the religious group to be registered as a corporation. Even if they are not registered, the members of religious organization may perform acts not contrary to law, morals, good customs, public order, or public policy by agreement. This religious group, when they are unregistered, they do not acquire all the rights and attributes of juridical person until they are registered. Because they are unregistered, this religious group are merely an organization that has no legal personality, and their members themselves are held personally liable for their acts. That's all for my report, attorney. Thank you.
So we have here section 111, the acquisition and alienation of property. So any corporation sole may purchase and hold real estate and personal property for its church, charitable, benevolent, or educational purposes and may receive bequests or gifts for such purposes. So we have the mechanics for the acquisition or conveyance of properties. First, where the rules, regulations, and discipline of the religious denomination, sect or church or religious society or order concerned represented by such corporation sole regulate the method of acquiring, holding, selling, and mortgaging real estate and personal property. Such rules, regulations, and discipline shall control, and the intervention of the courts shall not be necessary. Second, if there are no pertinent rules and regulations, such corporation may sell or mortgage real property held by it by obtaining an order for that purpose from the RTC of the province where the property is situated. The application for leave to sell or mortgage must be made by petition, duly verified by the chief archbishop, bishop, priest, minister, rabbi, or presiding elder acting as corporation sole, and may be opposed by any member of the religious denomination, sect, or church represented by the corporation sole. The court shall grant the application upon proof made to the satisfaction of the court that notice of the application for leave to sell or mortgage has been given by publication or otherwise in such manner for such time as said court may have directed, and that it is to the interest of the corporation that leave to sell or mortgage should be granted. Section 112, Filling of Vacancies. The successors in office of any chief archbishop, bishop, priest, minister, rabbi, or presiding elder in a corporation sole shall become the corporation sole on their accession to the office and shall be permitted to transact business as such upon filing a copy of their commission, certificates of election, or letters of appointment duly certified by any notary public with the commission during any vacancy in the office of the chief archbishop, bishop, priest, minister, rabbi, or presiding elder of any religious denomination, sect, or church incorporated as a corporation sole, the property, the persons or person authorized by the rules, regulations, or discipline of the religious denomination, sect, or church represented by the corporation sole to administer the temporalities and manage the affairs, estate, and properties of the corporation sole shall exercise all the powers and authority of the corporation sole during such vacancy. Both the RCCP and the Corporation Code do not provide for the term of a religious corporation, whether classified as a corporation sole or a corporation aggregate. However, it has been opined that the law never intended to limit the corporate life of religious corporations. Hence, they may be allowed to exist perpetually, unless a term is fixed in the Articles of Incorporation. So, Section 13 Dissolution. A corporation sole may be dissolved and its affairs settled voluntarily by submitting to the Commission a verified declaration of dissolution, setting forth the name of the corporation, the reasons for dissolution and winding up, the authorization for the dissolution of the corporation by the particular religious denomination, sect, or church, and the names and addresses of the persons who are to supervise the winding up of the affairs of the corporation. Upon approval of such declaration of dissolution by the Commission, the corporation shall cease to carry on its operations except for the purpose of winding up its affairs. After the expiration of the term fixed in the Articles of Incorporation, the religious corporation is deemed dissolved. However, it may continue to act as an ordinary religious church or group or an ordinary organization created by agreement of the parties. Section 114 Religious Societies. Unless forbidden by competent authority, the Constitution, pertinent rules, regulations, or discipline of the religious denomination, sect, or church of which it is a part, any religious society, religious order, diocese, synod, or district organization of any religious denomination, sect, or church may, upon written consent and or by an affirmative vote at a meeting called for the purpose of at least two-thirds of its membership, incorporate for the administration of its temporalities or for the management of its affairs, properties, and estate by filing with the commission articles of incorporation verified by the affidavit of the presiding elder, secretary or clerk or other member of such religious society or religious order or diocese, synod or district organization of a religious denomination, sect or church, setting forth the following: that the religious society or religious order or diocese, synod, or district organization is a religious organization of a religious denomination, sect, or church. B, that at least two-thirds of its membership has given written consent or has voted to incorporate at a duly convened meeting of the body. C, that the incorporation of the religious society or religious order or diocese, synod, or district organization is not forbidden by competent authority or by the Constitution, rules, regulations, or discipline of the religious denomination, sect, or church of which it forms part. D, that the religious society or religious order or diocese, synod, or district organization desires to incorporate for the administration of its affairs, properties, and estate. E, the place within the Philippines where the principal office of the corporation is to be established and located, and F, the names, nationalities, and residence addresses of the trustees, not less than 5 nor more than 15, elected by the religious societies or religious order or the diocese, synod, or district organization to serve for the first year or such other period as may be prescribed by the laws of the religious society or religious order or of the diocese, synod, or district organization. The RCCP does not require any religious group to be registered as a corporation. Even if not registered, the members of the religious organizations, by agreement, may perform acts not contrary to law, morals, good customs, public order, or public policy. However, an unregistered religious group does not acquire all rights and attributes of a juridical person if not registered. A religious group may be registered either as a corporation sole under sections 108 to 113 of the RCCP, corporation aggregate or religious society under section 114, or ordinary non-stock religious corporation under sections 86 to 94. Nature of a corporation sole. It is a special form of corporation usually associated with the clergy. It was also designed to facilitate the exercise of the functions of ownership carried on by the clerics for and on behalf of the church that was regarded as the property owner. It also consists of only one person. Unlike ordinary corporation, a corporation sole is not required to file bylaws because it is governed by the rules, regulations, and discipline of its religious denomination, sect, or church. The articles of incorporation of a corporation sole, as well as its articles of faith or rules of discipline, already contain the provisions normally embodied in the bylaws of the ordinary corporation. So the state cannot meddle into the purely ecclesiastical affairs of the religious corporation. However, courts can take cognizance of cases involving a religious corporation if the matter does not involve purely ecclesiastical affairs. So religious corporations, being a corporate entities and as grantees of primary franchise, are subject to the jurisdiction of the sect. So even with their religious nature, the sect may exercise jurisdiction over them in matters that are legal and corporate. So, here, for example, courts can take cognizance of cases involving the validity of disaffiliation of a member. A merger between a corporation sole and another religious corporation, if not forbidden by the Constitution and the rules and regulations or discipline of the religious denomination, sect, or church, may be allowed since there is no provision in the Corporation Code and the RCCP that prohibits such merger. So a corporation sole can be converted into a corporation aggregate by mere amendment of its articles of incorporation. So here we have the one person corporation. In section 115, the applicability of provisions to one person corporation. So the provisions of this title shall primarily apply to one person corporations. Other provisions of this code apply suppletory except as otherwise provided in this title. So OPCs are introduced in the RCCP as part of the effort to enhance the ease of doing business in the country. So allowing it encourages entrepreneurship and the formation of small businesses by authorizing the establishment of OPC. So it is also consistent with the Section 2 of Article 2 of the Constitution that states that the state shall encourage private enterprise and provide incentives to it needed investment in recognition of the private sector's indispensable role. So the requirement also to have at least five incorporators has been a common stumbling block for many investors. So as a consequence, investors name individuals with no real interest. So, as corporations in the as incorporators in the corporation, just to comply with the legal requirement, it is a common knowledge that sometimes people get their drivers, their maids, or their cooks just to form the required five. So with OPCs, businessmen, including small businessmen, need not resort to nomination of dummies as incorporators or members of the corporation when in fact it is a corporation belonging only to one person.
One person corporation, or commonly known as OPC. It is a corporation with a single stockholder. The OPC has a personality separate and distinct from its stockholder. The single stockholder is limited to: first is natural person, second trust, and third is estate of deceased person. So the trust here is being referred to in section 116 of the RCCP. It does not include trust entities such as trust companies that are regulated by the Bangko Sentral ng Pilipinas. So the trust here means that it is the subject being managed by a trustee. The trustee exercises fiduciary duty over the trust. So the intent of the legislators is that there is no limit to the number of OPCs one may avail of. In other words, one person may incorporate two or more OPCs. So the prohibited persons are the following. First is the banks and quasi banks, pre-need trust, insurance, public and publicly listed companies, and non-chartered government-owned and controlled corporations. Second is a natural person who is licensed to exercise a profession may not organize as one-person corporation for the purpose of exercising such profession except as otherwise provided under the special laws. So the rationale of OPC is that they are introduced in the RCCP as part of the effort to enhance the ease of doing business in the country. So by allowing OPCs, it encourages entrepreneurship and formation of small businesses by authorizing the establishment of one person corporation. So it is also consistent with the provisions in the Constitution that states that the state shall encourage private enterprise and provide incentives to needed investments in recognition of the private sector's indispensable role. So it was explained that the current provision requiring corporations to have at least five incorporators has been a common stumbling block for many investors because there are incorporators that has no real interest. So, as incorporators in the corporation, just to comply with the legal requirement, some investors included their drivers, their maids, or their cooks, even without the common knowledge, just to have or just to comply with the legal requirement. So, the one thing that will change in having OPC is that a single person can now put up a corporation. Businessmen, including small businessmen, need not to resort to the nomination of dummies as incorporators or members of the corporation, when in fact it is a corporation belonging to one person. So the innovation is a recognition of present day realities and the fact that OPCs are recognized worldwide. Minimum capital stock is not required for one person corporation. The authorized capital stock is not required except as provided by special law. For example, a foreign national who wants to organize an OPC that is engaged in retail trade can only do so if he or she complies with the minimum capitalization requirement under Republic Act number 8762. The paid up capital. So unless and under the regulation issued by the SEC, otherwise it is required by applicable laws or regulations, no portion of the authorized capital is required to be paid up at the time of the incorporation. Articles of Incorporation. So, SEC regulations provide that the OPC shall file its article of incorporation in accordance with the requirements of Section 14 of the RCCP. The Articles of Incorporation must set forth its primary purpose, principal office address, term of existence, names and details of the single stockholder, its nominee, and the alternate nominee, and the authorized, subscribed, and paid up capital, and such other matters consistent with law and which may be deemed necessary and convenient. So here is an example of an article sample format of the article of incorporation. As you can see, the articles of incorporation, name of one person corporation. First, the name of the said corporation. Second, the purpose or purposes for which the corporation is incorporated for. Third is the principal office of the OPC where it is located. Fourth is that the OPC shall have perpetual existence or its existence. Fifth is the name, the nationality, and residence address of the single its director, president of the OPC. Sorry. Sixth is that the names, the nationalities, residence addresses of the nominees and the alternate nominee. Seventh is the capital stock of the OPC. Eighth is the number of shares of the authorized capital stock. Nine, nine ninth is the self-appointed treasurer, its acknowledgement that it received the names and for the benefits of the corporation. Next is 10th is the undertaking to change the name of the OPC if ever. 11th, the transfer of stocks or interest, and 12, the fiscal year where it begins and when it shall end. So there should be an acknowledgement and the name and the signature of the incorporator. So bylaws. The OPC is not required to submit the file corporate bylaws. So in the stock or non-stock corporations, they are required to submit and file corporate bylaws. But in OPC, they are not required because but the bylaws provides the rules on the internal organization of the corporation. Since there is only one stockholder and director who can be the president and the treasurer at the same time, there is no more need to provide for extended rules on meetings, functions, and other matters that are usually provided for in the bylaws. The term of the OPC is that it is perpetual. However, since a natural person is not perpetual, that is why it is necessary for to provide for rules in case of incapacity or death of the single stockholder. It is dissolved when under the name of trustee. It is dissolved upon proof of termination of the trust and under the name of the estate of the person upon proof of partition, such as order of partition issued by the court in case of judicial settlement and deed of extrajudicial settlement in case of summary settlement of the estate. Display of corporate name. So one person corporation shall indicate the letters OPC either below or at the end of its corporate name so that it will be acknowledged that it is a one person corporation. Section 21. Single stockholder as director, president. So, the single stockholder shall be the sole director and president of the one person corporation. Directors and officers. So the one person corporation have the president, treasurer, corporate secretary. However, the difference is that single shareholder is also the sole director and president, and he may also concurrently assume the position of a treasurer. So that is the end of my report. Thank you.
So, good evening once again. This is Marian Sulapas. My report is about special corporations, particularly on one person corporations, sections 122 to 127. Section 122 of the Revised Corporation Code of the Philippines talks about the treasurer, corporate secretary, and other officers. So it is stated here that within 15 days from the issuance of its certificate of incorporation, the one person corporation shall appoint a treasurer, corporate secretary, and other officers as it may deem necessary and notify the commission thereof within 5 days from the appointment. So a treasurer, while the single stockholder can appoint another person as treasurer, the single stockholder may also assume such position. So what is this single stockholder? A single stockholder considered as the one who is likewise the self-appointed treasurer of the corporation, in which he or she shall give a bond to the commission in such a sum as may be required, provided that the said stockholder or treasurer shall undertake in writing to faithfully administer the one person corporation's funds to be received as treasurer, and to disburse and invest the same according to the articles of incorporation as approved by the commission. The bond shall be renewed every 2 years or as often as may be required. Section 10 of the SEC regulations on the OPC provides for the following rules concerning bond requirements for self-appointed treasurer. It is stated here that the single stockholder who assumes the possession of the treasurer shall post a surety bond to be computed based on the authorized capital stock or the ACS of the OPC as shown in the table. So as you can see on the right side of my slide, there is this table which shows the authorized capital stock, and on the left side is the surety bond coverage. So the bond here is a continuing requirement for so long as the single stockholder is the self-appointed treasurer of the OPC. Then the bond may be cancelled upon proof of appointment of another person as the treasurer and filing of amended form for appointment of officers. Let us now proceed to Section 123 of the Revised Corporation Code of the Philippines, and this is all about the special functions of the corporate secretary. So the president cannot function concurrently as the corporate secretary. It was pointed out that Section 123 of the RCCP assigns special functions to the corporate secretary, which necessitate that the single stockholder may not appoint himself as the corporate secretary. The prohibition for the single stockholder to assume the position of the corporate secretary was necessitated by the very nature of the organization. For example, one of the special functions of a corporate secretary is to notify the SEC of the death of the single stockholder, which would not likely happen if the corporate secretary, who is tasked with this responsibility, is also the same individual. So again, under Section 123, there are functions designated by the OPC to the corporate secretary. And these are: letter A, be responsible for maintaining the minutes book and or records of the corporation. Letter B, notify the nominee or alternate nominee of the death or incapacity of the single stockholder, which Notice shall be given no later than 5 days from such occurrence. Letter C, notify the commission of the death of the single stockholder within 5 days from such occurrence and stating in such notice the names, residence addresses, and contact details of all known legal heirs. And lastly, call the nominee or alternate nominee and the known legal heirs to a meeting and advise the legal heirs with regard to, among others, the election of a new director, amendment of the Articles of Incorporation, and other ancillary and or consequential matters. Okay, let us now proceed to section 124, which is about to nominate and alternate nominee rather. So the single stockholder is required to designate a nominee and an alternate nominee named in the Articles of Incorporation, who shall replace the single stockholder in the event of the latter's death and or incapacity. And then the written consent of both the nominee and alternate nominee shall be attached to the application for the incorporation, as stated in Section 124 of the Revised Corporation Code of the Philippines. And then the nominee designated by the single stockholder is the one who shall, in the event of the single stockholder's death or incapacity, take the place of the single stockholder as director and shall manage the corporation affairs. The nominee also must consent, and such consent may be withdrawn in writing any time before the death or incapacity of the single stockholder. So that's all for section 124. Let us now proceed to section 125, which is about the term of nominee and alternate nominee. So the length of time that the nominee shall sit as director and manage the affairs of the OPC would depend on whether there is only a temporary vacancy, such as a temporary incapacity of the single stockholder, or a permanent vacancy, as in the case of the permanent incapacity or death of the single stockholder. So, in case of a temporary incapacity of the sole shareholder, the nominee shall sit as a director and manage the OPC's affairs until the stockholder, by a self-determination, regains the capacity to assume such duties. Section 12 of the SEC Memorandum Circular Number 7, Series of 2019, provides that in case the single stockholder becomes incapacitated, the nominee can take over the management of the OPC as director and president. At the end of incapacity, the single stockholder can resume the management of the OPC. So another thing in this section, it also talks about the death or the permanent incapacity. So, in case of death or permanent incapacity of the sole shareholder, the nominee shall manage the OPC's affairs until the legal heirs of the single stockholder have been lawfully determined, and the heirs have designated one of them or have agreed that the state shall be the single stockholder of the OPC. So let us now proceed to the next section, which is about the change of nominee or alternate nominee. The single stockholder may, at any time, without need to amend the Articles of Incorporation, change its nominee and alternate nominee by submitting to the SEC the names of the new nominees and their corresponding written consent. So a sample form for the notice of the change of nominee and alternate nominee is provided in and attached to the SEC Memorandum Circular Number 7 Series of 2019 dated on April 25, 2019. So next section, this is about the minutes book. So a one-person corporation is required to maintain a minutes book which shall contain all actions, decisions, and resolutions taken by the one-person corporation. It shall be sufficient to prepare a written resolution signed and dated by the single stockholder and recorded in the minutes book of the OPC. Then the date of recording in the minutes book shall be deemed to be the date of the meeting for all purposes under the revised Corporation Code of the Philippines. Okay, so that's all for my assigned topic. Ms. Princess Zaballero will continue to discuss the succeeding sections under one-person corporations. Thank you very much.
Good evening, everyone. I am Princess Rose V. Zavallero. I will continue to discuss the one-person corporation under the sections 128 to 133 and some part of the topic of dissolution. Section 128, records in lieu of meetings. So, this provision provides that when action is needed on any matter, it shall be sufficient to prepare a written resolution, signed and dated by a single stockholder, and recorded in the minutes book of the one-person corporation. The date of the recording in minutes book shall be deemed to be the date of the meeting for all purposes under this code. Section 129, so reportorial requirements. The one-person corporation shall submit the following within such period as the Commission may prescribe. First is the annual financial statements audited by an independent certified public accountant, provided that if the total assets or total liabilities of the corporation are less than 600,000, the financial statement shall be certified under oath by a corporation's treasurer and president. Second is a report containing explanation or comments by the president on every qualification, reservation, or adverse remark or disclaimer made by the auditor in the latter's report. The next requirement is a disclosure of all self-dealings and related parties transactions entered into between the one-person corporation and and the single stockholder. And lastly is the other reports as the Commission may require. For the purposes of this provision, the fiscal year of the one-person corporation shall be that set forth in its articles of incorporation, or in the absence thereof, the calendar year. So the Commission may place the corporation under delinquent status should the corporation fail to submit the reportorial requirements three times consecutively or intermittently within the period of 5 years. Section 130, liability of a single shareholder. A sole shareholder claiming limited liability has burden of affirmatively showing that a corporation was adequately financed. Where the single stockholder cannot prove that the property of the one-person corporation is independent of the stockholder's personal property, the stockholder shall be jointly and severally liable for all the debts and other liabilities of the one-person corporation. The principles of piercing the corporation veil applies with the equal force to one person corporation as with the other corporation. Separate personality. An OPC has personality that is separate and distinct from single stockholder. Hence, generally, the liabilities of the OPC are not the liabilities of single shareholder. The general rule is still the limited liability rule. However, while the single stockholder's liability is also limited to his investment, said single shareholder claiming limited liability has the burden of affirmatively showing that the corporation is adequately financed. Piercing the veil of corporate fiction. The principle of piercing the corporate veil applies with equal force to OPC as with the other corporation. Hence, any corporate creditor who wishes to make the single shareholder liable for the corporate obligation must establish the probative factors to justify the piercing. However, the RCCP provides for the probative factor that can result in the personal liability of the single shareholder. The RCCP also provides that where the single stockholder cannot prove that the property of the OPC is independent of the stockholder's personal property, the stockholder shall be jointly and severally liable for the debts and other liabilities of OPC. Section 131, Conversion from an ordinary corporation to a one-person corporation. When a single stockholder acquires all the stocks of an ordinary stock corporation, the latter may apply for conversion into a one-person corporation, subject to submission of such documents as the Commission may require. If the application for conversion is approved, the Commission shall issue a certificate of filing of amended articles of incorporation reflecting the conversion. The one-person corporation converted from the ordinary stock corporation shall succeed the latter and be legally responsible for all the latter's outstanding liabilities as of the date of conversion. So this provision explains the conversion to OPC. So the conversion from an ordinary corporation to an OPC is possible when a single stockholder acquires all the stocks of an ordinary stock corporation. This is the appropriate remedy if all the existing shares in an ordinary corporation actually belongs to a single shareholder. So under the corporation code, the single shareholder could not have continued the corporate existence alone because at least five directors were then required to form and operate as a corporation. The person or shareholder who wanted then to avail the corporate vehicle in business was thus constrained under the corporation code to designate at least four nominee shareholders who can then be elected to complete the five-member board. So the ordinary corporation is not deemed dissolved if it is converted to an OPC. So the legal personality continues. Hence, it was provided earlier that the one-person corporation converted from an ordinary stock corporation shall succeed the latter and be legally responsible for all the latter's outstanding liabilities as of the date of conversion. Section 132, Conversion from a one-person corporation to an ordinary stock corporation. A one-person corporation may be converted into an ordinary stock corporation after due notice to the commission of such fact and of the circumstances leading to the conversion, and after compliance with all other requirements of the stock corporation under this code and applicable rules. Such notice shall be filed with the commission. So the law allows the conversion of an OPC to an ordinary corporation. This may be happen if the OPC becomes bigger and the single shareholder can no longer perform the functions of a stockholder, the governing board and the president of the same time. The business may have been may have become more complex and time consuming that the board consisting of more than one director becomes necessary. In addition, the single shareholder may want to raise additional funds from other person, hence the necessity of opening the corporation to the other investor. So the next topic is Title 14, Dissolution. Under 133, Methods of Dissolution. A corporation formed or organized under the provisions of this code may be dissolved voluntarily or involuntarily. Dissolution is an extinguishment of the franchise of a corporation and a termination of its corporate existence. Dissolution implies the termination of the corporation's existence and its author extinction and obliteration as an entity or body. Voluntary dissolution may involve cases when no creditors are affected and cases when creditors are affected. And in involuntary dissolution, the sovereignty of from which a corporation derives its existence has a vital interest in the continued exercise of the corporate franchise and may be undoubtedly inquire civilly in the propriety of such exercise. The fact that the state issued a franchise does not stop it from forfeit the franchise for the non-use or misuse thereof. That ends with my report. Thank you for listening.
Good evening, class. Good evening, ma'am. So, for the continuation of our report, the dissolution of corporation. First, let us define the meaning of dissolution. Dissolution is the extinguishment of the franchise of a corporation and the termination of its corporate existence. Section 134 of the Revised Corporation Code, voluntary dissolution where no creditors are affected. If the dissolution of a corporation does not prejudice the rights of any creditor having a claim against it, the dissolution may be affected by the majority vote of the Board of Directors or Trustees and by resolution adopted by the affirmative vote of the stockholders owning at least majority of the outstanding capital stock or majority of the members of a meeting to be held upon the call of the creditors or trustees. So, verified request for dissolution shall be filed with the commission. So, stating the grounds, no, the reason for the dissolution, the form, manner, time, and when the notices were given, the names of the stockholders and directors or members or and trustees who approve the dissolution, the date, place, and time of the meeting in which the vote was made, and details of publication. So the corporation shall submit the following to the commission. First, a copy of the resolution authorizing the dissolution, certified by a majority vote of the board of directors or trustees and countersigned by the secretary of the corporation. Second, the proof of publication. And third, the favorable recommendation from which the appropriate regulatory agency when necessary. So the procedures, no, it should be within 15 days from receipt of the verified request for dissolution, and in the absence of any withdrawal within said period, the commission shall approve the request and issue the certificate of dissolution. So the dissolution shall take effect only upon the issuance of the commission of a certificate of dissolution. Section 135, voluntary dissolution where creditors are affected. So the procedure and contents of petition. Where the dissolution of a corporation may prejudice the rights of any creditor, a verified petition for dissolution shall be filed with the commission. So the petition shall be signed by the majority of the corporation's board of directors or trustees. So verified by its president or secretary or one of its directors or trustees, and shall set forth all claims and demands against it, and its dissolution was resolved upon by the affirmative vote of the stockholders representing at least 2/3 of the outstanding capital stock or at least 2/3 of the members of at a meeting of its stockholders or members called for that purpose. So the petition shall likewise state the reason for the dissolution, the manner, form, the time when the notices were given, the date, place, and time of the meeting in which the vote was made. So the corporation shall submit to the commission the following: a copy of the resolution authorizing the dissolution, certified by a majority of the board of directors or trustees and countersigned by the secretary of the corporation, and a list of all its creditors. If the petition is sufficient in form and substance, the commission shall pay by an order reciting the purpose of the petition, fix a deadline for filing objections to the petition, which date shall not less than 30 days, not nor more than 60 days after the entry of the order. So, upon 5 days notice given after the date on which the right to file the objections as fixed in the order has expired, so the dissolution shall take effect only upon the issuance by the commission of a certificate of dissolution. So, Section 136, the dissolution by shortening corporate term. A voluntary dissolution may be affected by amending the Articles of Incorporation to shorten the corporate term to pursuant to the provisions of this code. A copy of the amended Articles of Incorporation shall be submitted to the Commission in accordance with this code. So, unless such term is extended. Section 137, the withdrawal of request and petition for dissolution. A withdrawal of the request for dissolution shall be made in writing, so duly verified by any incorporator, director, trustee, shareholder, or member, and signed by the same number of incorporators, creditors, trustees, shareholders, or members necessary to request for the dissolution as set forth in the foregoing sections. So, upon receipt of the withdrawal of request for dissolution, the Commission shall withhold action on the request for dissolution shall, after investigation, so make a pronouncement that the request for dissolution is deemed withdrawn. Direct a joint meeting of the board of directors or trustees and the stockholders or members for the purpose of ascertaining whether to proceed with dissolution. Letter C. Issue such other orders as it may deem appropriate. So, Section 138, the involuntary dissolution. Before, there are kinds of involuntary dissolution, such as the involuntary dissolution by non-use of corporate charter, involuntary dissolution by order of the SEC, or and involuntary dissolution by legislative enactment. But this Section 138, involuntary dissolution, talks about the expiration of its term. So, a corporation is dissolved upon the termination of the term provided in its Articles of Incorporation. So, a corporation may be dissolved by the Commission motu proprio or upon filing a verified complaint by any interested party. So, the following may be grounds for dissolution of corporation: non-use of corporate charter as provided under Section 21 of this code, continuous in operation of a corporation as provided under Section 21 of this code, so upon receipt of lawful court order dissolving the corporation. Letter D, upon finding by final judgment that the corporation procured its incorporation through fraud. Letter E, Upon finding by final judgment that the corporation was created for the purpose of committing concealing or aiding the commission of securities violation, smuggling, tax evasion, money laundering, or graft and corrupt practices, or committed or aid in the commission of securities violations, smuggling, tax evasion, money laundering, graft and corrupt practices, and its stockholders knew, repeated, unknowingly tolerated the commission of graft and corrupt practices or other fraudulent or illegal acts by its creditors, trustees, officers, or employees. So, Section 139, the corporate liquidation. Let us first define the liquidations. Meaning is, so liquidation is the process of winding up the affairs of corporation and entails the collection of all assets, the payment of all its creditors, and the distribution of the remaining assets. The manner of liquidation may be provided for in the corporate bylaws, and this would prevail unless it is inconsistent with law. So in the case of Yo versus UK 1, June 18, 2009. So section 139, the liquidation, the corporate liquidation, no? So except for banks which shall be covered by the applicable provisions of Republic Act number 7653, otherwise known as the New Central Bank Act as amended, and Republic Act number 3591, otherwise known as Philippine Deposit Insurance Corporation Charter as amended. So, every corporation whose charter expires pursuant to its articles of incorporation is annulled by forfeiture, or whose corporate existence is terminated in any other manner, shall nevertheless remain as body corporate for 3 years after the effective date of dissolution. So for the purpose of prosecuting and defending suits by or against it, and enabling it to settle and close its affairs, no, dispose of and convey its property and distribute its assets, but not for the purpose of continuing the business for which it was established. So at any time during the said 3 years, the corporation is authorized and empowered to convey all of its property to trustees for the benefit of stockholders, members, creditors, and other persons in interest. So, except as otherwise provided in sections 93 and 94 of this code, upon the winding up of corporate affairs, any asset distributable to any creditor or stockholder or member who is known or cannot be found shall be escheated in favor of the national government. So, except by decrease of capital stock and as otherwise allowed by this code, no corporation shall distribute any of its assets or property except upon lawful dissolution and after payment of all its debts and liabilities. So, after the dissolution, the corporation shall nevertheless continue as corporate body, not for continuing the business for which it was established, but for the following. So, to prosecute and defend suits by or against it, to enable it to settle and close its affairs, to dispose of and convey its property, to distribute its assets. So, that's all for my report. Thank you.
So we have here the bar questions. In the first question, AAA Corporation is a bank. The operations of AAA Corporation as a bank were not doing well. So, to avert any bank run, AAA Corporation, with the approval of the Monetary Board, sold all its assets and liabilities to BBB Banking Corporation, which includes all deposit accounts. In effect, then, BBB Corporation will service all deposits of all depositors of AAA Corporation. So the question here is A, will the sale of all assets and liabilities of AAA Corporation to BBB Banking Corporation automatically dissolve or terminate the corporate existence of AAA Corporation? And B, what are the legal requirements in order that a corporation may be dissolved? So we have here the answers. So as to the first question, no, AAA Corporation is an artificial being created by law and has a legal personality of its own. A corporation does not owe its existence upon the presence of assets and properties. It can only be dissolved in cases provided for by law. As such, AAA Corporation will subsist regardless of the sale of all of its assets and liabilities to another corporation. So, as to the second question, a corporation may be dissolved voluntarily by shortening of the corporate term and through involuntary dissolution. Involuntary dissolution, the action for dissolution must be approved by a majority of the directors or trustees and two-thirds of the stockholders representing the outstanding capital stock or members. Publication requirement and filed with SEC, which will issue certificate of dissolution. If there are creditors affected, there must be a hearing to hear the objections and claims of the creditors. In case of shortening of corporate term through amendment of the AOI, in involuntary dissolution through filing of a verified complaint with the SEC based on any ground provided by law or rules. So here, the Securities and Exchange Commission approved the amendment of the Articles of Incorporation of GHQ Corporation, shortening its corporate life to only 25 years in accordance with Section 120 of the Corporation Code. As shortened, the corporation continued its business operation until May 13, 1997, the last day of its corporate existence. Prior to the said date, there were a number of pending civil actions of varying nature but mostly money claims filed by creditors, none of which was expected to be completed or resolved within 5 years from May 30, 1997. If the creditors had sought your personal help at the time about whether or not the cases could be pursued beyond May 30, 1997, what would have been your advice? So the answer to that question is the cases can be pursued even beyond May 13, 1997, the last day of the corporate existence of GHQ Corporation. The corporation is not actually dissolved upon the expiration of its corporate term. There is still the period for liquidation or winding up. Question: X Corporation shortened its corporate life by amending its articles of incorporation. It has no debts but owns a prime property located in Quezon City. How would the said property be liquidated among the five stockholders of said corporation? Discuss two methods of liquidation. The answer: the prime property of X corporation can be liquidated among the five stockholders after the property has been conveyed by the corporation to the five stockholders by dividing or partitioning it among themselves in any two of the following ways. First, by physical division or partition based on the proportion of the values of their stock holdings. Or second, by selling the property to a third person and dividing the proceeds among the five stockholders in proportion to their stock holdings. Or third, after the determination of the value of the property, by assigning or transferring the property to one stockholder with obligation on part of said stockholder to pay the other four stockholders the amounts in proportion to the value of the stockholding of each. XYZ Corporation entered into a contract of lease with ABC Incorporated over a parcel of a real estate for a term of 20 years, renewable for another 20 years, provided that XYZ's corporate term is extended in accordance with the law. 4 years after the term of XYZ Corporation expired, but still within the period allowed by the lease contract for the extension of the lease period, XYZ Corporation notified ABC Incorporated that it is exercising the option to extend the lease. ABC Incorporated objected to the proposed extension, arguing that since the corporate life of XYZ Corporation had expired, it could no longer opt to renew the lease. XYZ Corporation countered that, withstanding the lapse of its corporate term, it still has the right to renew the lease because no quo warranto proceedings for involuntary dissolution of XYZ Corporation has been instituted by the Office of the Solicitor General. Is the contention of XYZ Corporation meritorious? The answer is no. XYZ Corporation's contention is not meritorious. XYZ Corporation was dissolved ipso facto upon the expiration of its original term. It ceased to be a body corporate for the purpose of continuing the business for which it was organized, except only for purposes connected with its winding up or liquidation. Extending the lease is not an act to wind up or litigate XYZ's affairs. It is contrary to the idea of winding up the affairs of the corporation. Question. The corporation, once dissolved, thereafter continues to be a body corporate for 3 years for purposes of prosecuting and defending suits by and against it and of enabling it to settle and close its affairs, culminating in the final disposition and distribution of its remaining assets. If the 3 year extended life expires without a trustee or receiver being designated by the corporation within that period, and by that time the corporate liquidation is not yet over, how, if at all, can a final settlement of corporate affairs be made? The answer: the liquidation can continue with the winding up. The members of the BOD can continue with the winding up of the corporate affairs until final liquidation. They can act as trustees or receivers for this purpose. Where no receiver or trustee has been designated after dissolution, the board of directors or trustees itself may be permitted to so continue as trustees by legal implication. In the absence of the BOD or BOT, those having a pecuniary interest in the corporate assets, stockholders, or creditors may make a proper representations with SEC for working out a final settlement of the corporate concerns, or the only surviving stockholder or director, or the counsel who prosecuted and defended the interest of the corporation. Father X, an American priest who came from New York, registered the Diocese of Bacolod of the Roman Catholic Church, which was incorporated as a corporation sole. There were years when the head of the diocese was a Filipino, but there were more years when the heads were foreigners. Today, the head is an American again. Why donated a piece of land located in Bacolod City for use as a school? Which statement is most accurate? A. The Register of Deeds of Bacolod City can refuse to register and transfer the title because the present head of the corporation sole is not a Filipino. B. The nationality of a corporation sole depends upon the nationality of the head at any given time. C. A corporation sole, regardless of the nationality of the head, can acquire real property either by sale or donation. And D. A corporation sole is not legally allowed to own real property. The answer is letter C. A corporation sole, regardless of the nationality of the head, can acquire real property either by sale or donation. Under Section 111 of the Revised Corporation Code, a corporation sole may purchase and hold real estate and personal property for its church, charitable, benevolent, or educational purposes and may receive bequests or gifts for such purpose. Your client Diane approaches you for legal advice on putting up a medium sized restaurant business that will specialize in a novel type of cuisine. As Diane feels that the business is a little risky, she wonders whether she should use a corporation as the business vehicle or just run it as a single proprietorship. She already has an existing corporation that is producing meat products profitably and is also considering the alternative of simply setting up the restaurant as a branch office of the existing corporation. Briefly explain to your client what you see as the legal advantages and disadvantages of using a separate corporation, a single proprietorship, or a branch of an existing corporation for the proposed restaurant business. The answer: if Diane will set up a separate corporation, her liability for its obligations and losses will be limited to the amount of her subscription in the absence of showing that there is a ground to disregard its separate juridical personality. If she were to operate a single proprietorship, her liability for its debts and losses will be unlimited. The formation and operation of a corporation require a great deal of paperwork and record keeping. This is not the situation in the case of a single proprietorship. If Dayan will form a separate corporation, it can raise more funds for the business than if she were to set up a single proprietorship. If she were to set up the restaurant as a branch office, an existing corporation, the corporation will have more funds as capital than if she were to form a separate corporation. However, all the assets of the existing corporation will be liable for the debts and losses of the restaurant business.